Good afternoon, everyone. My name is John Cornwell, and I'm the Director of Practice Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's webinar, which is sponsored by our Commercial Litigation Practice Group. For many of us, litigation is a dark cloud filled with a lot of unknowns and potential significant costs in terms of time and money. And being able to navigate through litigation is a real challenge for many businesses. We're fortunate to have with us today Matt Betcher and Eric Johnson, who are members of Plunkett Cooney's Commercial Litigation Group. If anyone can demystify the seemingly inevitable aspect of business risk, it's them. Before we get started, I'd like to take just a few moments to provide you with some background about our law firm and about our presenters. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. We have 7 Michigan offices, as well as locations in Chicago, Indianapolis, and Columbus, Ohio. Plunkett Cooney is one of the Midwest's most accomplished law firms as well in the areas of business, finance, commercial litigation, and real estate. The members of our commercial litigation group routinely represent clients in contract disputes, business torts, real estate matters, antitrust claims, commercial landlord-tenant disputes, and much more. Our presenters today, as I mentioned, are Matt Betcher and Eric Johnson. I'll start with Matt and give you a little bit of background about him. And actually, both of our attorneys on the call today are in our Bloomfield Hills office in Michigan. And Matt, for over 30 years now, has successfully represented clients in complex commercial litigation. He handles an array of issues, including real property, banking conflicts, contract disputes, class action defense, and business torts. He's a co-leader of our commercial litigation practice group, and he's received numerous honors and awards for his work, including the prestigious peer review rating AV Preeminent from Martindale-Hubbell, which is a leading international peer review organization. He's also won some top lawyer honors from other outlets, including The Business Magazine. Eric Johnson focuses his practice primarily in the area of business litigation. He's admitted to practice in Illinois and Michigan, and his experience includes a range of matters in state and federal court in such areas as contract disputes, employment litigation, loan workouts, partnership disputes, and trademark actions. And now just a couple of quick housekeeping notes about today's program, and then I'll turn the program over to our presenters. For the Q&A portion of our webinar, we encourage you to ask questions as the program progresses. You could do that using the questions widget in your GoToWebinar display. Just simply type those in, and I will ask them along the way if I can fit them into the discussion. And we'll also have a Q&A period at the end of the program. So if nothing occurs to you until a little bit later, that's fine too. The only thing that we ask is that you don't ask questions of a too specific a nature about ongoing matters within your workplace. We simply don't want to have to get into any of those issues, and frankly, we're not able to anyways. We need to keep things of a more general nature, which we hope you will understand. So thanks again for attending today's webinar. I'll turn it over now to Matt and Eric. And Matt, I believe you're up first, so please take it away.
Yes, good morning, everybody. Thanks for joining us. My goal this morning is to demystify some of the things that we do. I think oftentimes my clients think I purposely try to confuse them to make my job seem harder than it is, or that I have more value than I actually bring. In reality, just like in every profession, things that you become comfortable with, you forget that people often don't know the vernacular. They don't know the terms that you commonly use, knowing what they mean, and you assume the listener does. And I can't tell you how often I've sat with new clients or even existing clients, many of whom who've never been sued before or have had to bring a lawsuit before. And when I start talking about some of the topics that we're going to talk about this morning, there's absolutely no betrayal in their face that they don't understand me. Yet later on, it became abundantly clear that they did not. And I think human nature is such that we don't want to betray our own ignorance. But the reality is, in litigation, none of this is intuitive. There's no reason for you to know what we're talking about when we talk about things like jurisdiction, or removal, or any of the other topics that we're going to cover this morning. And I encourage you during the program today, if we're not going to get into depth very much, because that's not the point of this exercise. But if you do have questions, I encourage you to bring them right away. I'd like to tackle any questions you may have as we go forward, rather than waiting to the end, although we can certainly do that as well. So let me jump right in and talk first about some of the governing ideas and principles that courts use and operate under. The first thing we talk about, and you've probably seen this in television and in movies, where lawyers will talk about jurisdiction, judges will talk about jurisdiction. I don't have jurisdiction to do that, or I do have jurisdiction to do that. Well, what the devil is jurisdiction? Jurisdiction is really nothing more than the court's authority to handle a particular matter involving a particular set of parties. That's really all it is. When you hear jurisdiction, think authority. I have the authority to decide this dispute. I have the authority to order you to do that. That's what we're talking about when we're talking about jurisdiction. Jurisdiction, though, is split into two separate ideas. One is personal jurisdiction, and the other is what's called subject matter jurisdiction. But again, personal authority, subject matter authority. If you think of it in those ways, jurisdiction becomes fairly clear. Personal authority, meaning the court has the authority over you or the other side. How does that happen? Well, principally it happens because the court in your county, if you live in Oakland County, Michigan, an Oakland County Circuit Judge is going to have authority over you because you live there. You might also have, in a business context, a contract where the contract consents to jurisdiction in a particular place. Your business might be located in Oakland County, but it might do business in Ohio. But that may mean an Ohio judge has authority over your business, because businesses are people too. So personal jurisdiction is just authority over the people, including your business. Subject matter jurisdiction, on the other hand, is subject authority, meaning the judge has the authority to decide that particular dispute. There are typically, lawyers will say Michigan has one court, but it's split into a bunch of different courts. And by that I mean you have your probate court, you have your state civil court, you have your district court, you have your small claims court. But by law, it's really one court. It's just split up into different areas of subject authority. So for example, your local district court will have civil authority over disputes that are valued no greater than $25,000. If it's more than that, it goes into the county circuit court. There may be probate disputes. You know, if you've ever had to, if someone ever died in your family, they had a will or lacked a will, and you need a court authority to sell a piece of property, that would be handled in a probate court, which is still part of the civil court, but it specializes in probate matters. So when we talk about subject matter jurisdiction, we're really just talking about authority over a particular type of dispute. Now, that dovetails into this idea of federal and state court jurisdiction, because we have a state system and we have a federal system. Both of those systems still look at the same questions of personal authority and subject matter authority. But this is where it can get a little confusing, because if you have a business in Oakland County and you get into a fight with another business in Oakland County, you might think that the case has to be filed in Oakland County and decided there. Well, maybe not. Maybe it turns out the party that you're fighting with is actually an Illinois corporation. Its principal place of business is in Illinois. They have a presence in Michigan, but they're actually an Illinois company. That case can get filed in federal court. Well, how does that happen? Well, because again, courts are creatures of authority, and there are federal laws that say federal judges decide two types of questions. One is called a federal question, meaning it's an area of law that was set aside for federal court. One of the best examples of that is patent law. Patent law disputes are decided in federal court. All sorts of other statutes will set up a dispute resolution opportunity through the federal courts. And Congress will give the federal courts authority to decide those claims. But one of the ways that your run-of-the-mill state court disputes can be heard in federal court is what I just described, where you have different parties from different states. There's a statute that allows that type of a state court dispute to be heard in federal court as long as its value is over $75,000. And we don't want to get hung up too much on that. But the point to be made is that if you get sued, or if you are contemplating having to file a lawsuit, you will have to look at jurisdiction or authority in both state and federal courts, because claims can sometimes be heard in either place. We're going to be talking principally about trial level courts, meaning where is the dispute originally heard, but you don't want to overlook the fact that the court systems also include courts of appeal, and in Michigan, there's a Michigan Supreme Court. If you get a decision in a trial court in Michigan in a circuit court and you don't like it, you have an appeal of right to the Michigan Court of Appeals. Appeals to the Michigan Supreme Court are only if that court decides your question is important enough for them to spend time considering it. And the system in the federal system is the same with the Court of Appeal and the United States Supreme Court. But again, jurisdiction in state and federal courts, think of it as authority. But let's jump into a related. Yeah, go ahead.
So I was going to ask you a question on this jurisdiction issue. You mentioned you might consent to personal jurisdiction in a contract. Does that mean that I could sign a contract and find out that I've consented to have a lawsuit against me in Florida?
You can, but it may turn out that even though your contract says I've consented to jurisdiction in Florida, that doesn't mean that your suit is actually going to be decided there, because you still have an opportunity to challenge the location of a lawsuit by what we're going to be talking about right now, which is venue. It's not unusual for a dispute to be suitable to be decided in more than one place. In your example, the parties might have had a contract that said, we're going to decide this in Florida. But actually, you don't really have a lot of contacts with Florida. And it would be more appropriate for the case to be decided in Michigan. And that goes to the question of venue. Venue, again, is a fancy word that simply means place where the dispute is going to be decided. Let's assume that the court in Florida and the court in Michigan both have the authority over the people involved and the dispute to decide it in either place. But it's more convenient in Michigan. It'd be because all the witnesses are here, all the documents that are related to the dispute are here. Maybe it involves a piece of property that's located here, and maybe it might become important for the judge or a jury to see the property, which couldn't be practically done if the case was being tried in Florida. So even when there's authority in another place, you can go to that other judge and say, Judge, yeah, you have authority to hear this, but we think it's more appropriate that the case be heard in Michigan. Transferring a case is much easier. Go ahead.
I was going to say, it sounds like what you're describing is that the courts are concerned, where is it fair to have this case heard on this person or this entity? That's kind of how it balances out, like what makes sense for the case, what are the pragmatic concerns?
Yeah, the judges, in my experience, are going to be more concerned about the fairness to third parties, like witnesses. They're going to be less concerned about the inconvenience to the parties themselves, particularly in business cases, where courts, if you've signed a contract that says you're going to try the case in Florida, they may hold you to it, because the presumption is that as a business owner, you're more sophisticated than someone who simply bought a microwave oven that doesn't work, only to find out that their sales contract says they have to arbitrate that dispute in Delaware. So yeah, fairness goes into it. Fairness is really a key component to venue. It can be heard there, but is it reasonable and fair that it be heard there? And the court's going to be more concerned about, is it fair to the third parties that are going to be dragged into court to testify in your fight versus the inconvenience to you? So venue, again, place of dispute can be changed simply by asking the judge to change the venue. And venue can be changed in Michigan. Let's use Michigan as an example as well. The suit gets filed in Wayne County, but the dispute is really over in Kent County, near Grand Rapids. That's where it should be filed, even though technically it's proper in Wayne County. You see that a lot with bigger companies where they have a presence throughout the state. And plaintiffs like to sue in Wayne County because they think the juries are more friendly there. But this is a case that more properly should be tried in Kent County. You can go to the Wayne County judge and say, Judge, you should transfer venue to Kent County for all of the reasons that you would otherwise say. The property's there, the dispute happened there, most of the witnesses are there, the documents are there. It's more fair that it be tried there. And that's just a request. You go to the judge and you say, we want to change our venue, or we want to change the place where our fight is going to happen. One of the things that I wanted to touch on, and I probably should have had this slide next to the jurisdiction one, is talking about the business court system that was developed in Michigan a few years ago. It was recognized by the legislature that we needed to have a dedicated court to handle business disputes. So there's a statute in Michigan that created what's called the business court. So if you have a business dispute, which is defined in the statute, and the easiest way to think about that, there's others, but if you have a business and you're fighting with another business over sale of goods, for example, that's a business dispute that's going to be required to be heard in a business court, assuming your county has a business court. And I don't know if they all do now. It's typically determined on population, I believe, but certainly Wayne, Oakland, Macomb, the Tri-County area, those counties all have business courts. So if you have a business dispute, you must file it in that court, because borrowing back from where we began, business court is limited to business disputes, but it's mandatory, meaning the court has the authority over all business disputes. as defined in the statute. So the court has what's called exclusive jurisdiction over business disputes.
Now, are there
The
other
advantages-
types of specialty? Sorry.
Yeah. We touched on a couple. Probate court is one where probate matters have to be heard in front of a probate judge. There's some family law matters have to be heard in front of certain judges. But for our purposes today, I want to focus solely on the notion of a business court because I think it's most applicable to the types of people on the webinar, and they're going to be the ones most important. So if you hear the term business court, what you want to take from that is that's a specialized court in Michigan that is set up to exclusively hear your business dispute.
Are there any related courts on the federal level? I'm thinking things like bankruptcy, which might impact a business case.
Bankruptcy courts are themselves a specialty court. They are a subset of the federal court system. And I promised I wouldn't bore anyone with details, but let me just bore you for a moment. The federal court system was set up in the United States Constitution as part of the government. You have the president, you have the Congress, and you have the courts. And so the courts have their own section of the Constitution which sets them up. It doesn't talk about bankruptcy courts, but what Congress has decided is that they needed a specialty court to hear bankruptcy matters. So bankruptcy courts were created by statute, and they have their own set of rules, and they have their own statutes that apply, and there are attorneys who specialize in bankruptcy matters. So if your business is looking at a bankruptcy or is doing business with someone who is in bankruptcy, you may very well find yourself in front of a bankruptcy judge. And that's just another subset of authority, if you will, or bankruptcy jurisdiction.
And could that be at the same time that you're involved in a dispute in the business court?
I've had cases in business court which, in the middle of a dispute, suddenly get dragged into bankruptcy court because one of the parties filed for bankruptcy. You can't have cases involving the same claims and the same parties being litigated in the same place at the same time, or in two places at the same time. So you're not going to be having a bankruptcy judge deciding, who's at fault in a contract between parties A and B, where at the same time your local business court judge is deciding the same issue. There's going to have to be a ferreting out of who's got the authority to decide that issue to proceed. But let's not get too bogged down in that, because I want to jump ahead to, we talked about the courts, we talked about the court's authority, we talked about the place for the fight. Well, how does the fight get started? And that's typically because a pleading is filed. So what is a pleading? A pleading is a fancy word that covers a variety of documents. A lawsuit gets filed by the drafting of a complaint. And a complaint is, think of it as a list of grievances. This is what the other side did wrong. This is how I've been harmed. And this is what I want the court to do. All of that would be put into a complaint. Pleadings are also defined as an answer to a complaint. What's called a counter complaint, meaning if you sue someone, they may have their own claim against you, and they will file what's called a counter complaint. You may also have a claim if there's two defendants. Say you have a fight with more than one defendant, more than one party that has done wrong to you, company A and company B. Well, because you started it, Company A and Company B may have their own fight amongst themselves, and they may file what's called a cross-claim. A pleading could also include what's called a third-party claim, where I sue you, but you decide that a third party who's not even named in my complaint is really at fault. And you decide to sue that person by what's called a third-party complaint. As we go forward, though, it's not important that you understand more than a complaint and an answer. That's what gets the lawsuit started. But we don't want to leave out a real important document, which is a summons. A summons, again, is a fancy word, but really what it is it's a court order directing you to appear in court to respond to a complaint. Now, in reality, the way you typically appear and respond is by filing a written answer with the court. But a summons is different than a complaint. A complaint is what we talked about, meaning a list of grievances. The summons comes from the court ordering the defendant, once they've been properly served, to appear and defend against the plaintiff's list of grievances. So what does it mean to be properly served? Because this is something that folks in business get confused about all the time. Serving a complaint meaning simply handing it to the person you're suing in its simplest form. I sue you, I see you on the street, I hand you a copy of the summons and the complaint, and now you've got to deal with it. You might also be served by someone showing up at your place of business and handing you a copy of the summons and a copy of the complaint. There's actually a court rule in the state court system which spells out how you serve a complaint and a summons on a person, on a partnership, on a corporation, on an unincorporated entity. There's a whole list of steps that lawyers have to follow. Folks like business owners don't necessarily need to know the ins and outs of that, but your lawyer needs to do that. The important things about a summons, and we'll talk about this a little bit later, is because it's a court order, there are time limits that go with it. Typically, it's in state court, it's 21 days. So if you receive a copy of a summons and a complaint, you only have 21 days to take action, or bad things will happen. We'll get into that a little bit later. So what happens when you get the summons and complaint? Or even before the summons and complaint happens, but the other side tells you, you know what, we're not going to be able to agree, we're going to have to sue you. There's a document that's referred to by lawyers as a litigation hold. And it's an important document that business people need to understand what it is and how important it is. And Eric will probably be able to share with you a war story or two about lawyers who came into court and their clients didn't preserve the evidence. Okay, so keep that on the shelf for the moment. Let me just go through a thumbnail sketch of what a litigation hold is. That's actually a name that's pretty intuitive. Litigation is happening or it's threatened, and we need you to hold all the information that might be relevant to that dispute. So that's all a litigation hold is. It's a directive by somebody to somebody to preserve information. So who sends it? Well, typically, in my experience, the litigation hold letter comes from me. And I send it to my own client. And I say, all right, you've been sued, or a lawsuit is being threatened against you. Here's a letter that spells out all the steps you need to take to preserve the information that the court is going to expect you to preserve. In the old days, when I was a baby lawyer, that wasn't a problem because there were no such things as personal computers, believe it or not. And all of the records were in paper, sitting in file cabinets, and there they would sit for years and years and years. Preserving them weren't problems. With the advent of computers and the almost uniform reliance upon computers to store information these days, the litigation hold letter takes on a new importance, because businesses oftentimes have document retention policies, especially small businesses. You know, they only have so much space on their server, and they can only keep information for short periods of time, sometimes as short as 30 days. Even big companies, you know, Fortune 500 companies, will only save information for short periods of time, because when you have tens of thousands of employees creating new emails every day, you know, the cost of preserving all of that for long periods of time can be extraordinary. So a litigation hold letter is typically a letter from me to my client saying, these are the steps you need to take to preserve information, including all of the information that you're saving on your computers. So if you have an automatic email purge, for example, that purges all your emails after 30 days, you need to take steps to suspend that when you get a letter from me directing you to hold your information. But you can also get litigation hold letters from the other side. I've had that happen where an attorney will write to me and say, okay, we're obviously going to have a fight. I'm demanding that you instruct your client to hold all of the relevant information. That can happen as well, but it's a little bit more unusual. You should care about these things because I think Eric can tell you a little bit about what a judge is likely to do when the judge finds out you didn't properly preserve your information.
So you have a couple problems. One is you can be sanctioned if you can't produce, if you didn't hold something that you're supposed to hold on to, and the other side's asking for it and says, this is very important that I have this, and you don't have it, you can be sanctioned either monetarily, or you can pull what's called a negative inference, which is what you do not want to pull. For example, if you have a contract dispute and you send an email to a customer or someone you had a relationship with and said, don't do this thing. I've asked you to come and pick up this thing from my company every week, and I sent you an email back in December that said, stop. And you didn't stop. You kept coming in, picking it up, and billing me. And the other side says, well, where's that? You didn't do that. And then they say, well, show me the email. And if you've destroyed that email, even if you told the customer or the vendor to stop doing what they were doing, you'll pull a negative inference because you destroyed it. So the other side gets the presumption that you didn't provide notice, and that could have serious consequences in a contract case.
Right. So the critical thing that my clients have to understand is that when they get a litigation hold letter from me, or even if they don't, if you think about it, if you're in a fight, you want to make sure that you take steps to preserve information that may be necessary. And it's frankly more often, in my experience, that my own clients have disposed of information that would have helped them. It's not the bombshell that is going to hurt their case. It's the helpful information, like Eric just described, where you gave notice, but you can't prove it because you eliminated the notice. And the only way you're going to get that is through the discovery process, and hopefully the other side will have that. So let's jump into that. Once the lawsuit gets filed, and you eventually will sit down with a judge, and the judge will set up a schedule, meaning you have to do certain things by certain times, including getting ready for trial. It used to be unique to the federal system, but now it's becoming part of our state system in Michigan, where parties are required to make what's called initial disclosures. And that's just it's information that typically would come out in discovery, but principally it's, all right, here are the people that are important to this dispute. Here's the types of documents and their location, documents and information that are going to be important to this dispute. I have insurance that might cover this, and if I'm the plaintiff, these are my damages. These are the types of broad categories of information that you're going to be required to disclose without anyone even asking for it. And that's set up in the case schedule, or if it's not in a case schedule, by court rule. And that's something that the lawyer is going to want to handle, but the lawyer is going to need your input, because the lawyer's not going to know who are the key people, isn't going to know, where you keep your documents or how you keep your documents. So when the lawyer's asking you for these things, oftentimes it's either as part of the initial disclosures or what's referred to as the discovery process, which follows. Once initial disclosures are made, the parties back and forth for a certain period of time, usually in the state system, at least 3 months, often more. In the federal system, it's typically as long as 6 months. You have a process of discovery where you can ask the other side, hey, we didn't get these documents. We want all of these types of records. We want all your email communications with party X, or we want all your payroll records for this period of time. You can also ask them to answer specific questions in writing. Describe your process for inspecting potential defective parts. Just identify all the people who would be involved in those types of inspections. You can set those out in written question form, which are called interrogatories. I don't know why we use that term, but we do. It's an interrogatory is simply a written question. A request for production is simply asking someone to turn over documents or information. There's also, as part of the discovery process, what's called a request for an admission. You can ask the other side to admit something that you don't think is disputed. Or if it is disputed, explain why. The discovery process might also include inspecting your premises. Maybe there was an accident on your premises, and it's important to see the layout. So the discovery process might include an inspection. It might include what's called a deposition, which is a fancy word for simply asking someone oral questions under oath. That usually happens in a lawyer's office with a court reporter writing down every word everyone says in a written transcript, which can later be used in the litigation process, including trial. Your discovery process might also include the use of experts. For example, if there's a fight over defective goods and you have to determine, was your inspection process reasonable? Maybe you have to bring in an expert on inspecting those types of goods to testify that in his or her opinion, your inspection process meets reasonable standards of reasonable commercial standards. All of that is part of the discovery process. And it can take a long time. It can take, as I said, several months. When you issue an interrogatory, a written question, or a request for production of documents, in the federal system, you get 30 days to respond. In the state system, you get 28 days, unless the court orders a shorter period of time. That's one of the biggest reasons why lawsuits take a long time, because the courts recognize that it can take a long time to get it ready for a trial. Okay, we're going to have to jump ahead because we're already running out of time. One of the things that's going to happen in a state court lawsuit is you're going to go through what's called case evaluation. Case evaluation is a system that was set up to try to resolve cases. It can happen in federal court, but the courts have no authority to force it to happen, so you can simply opt out of it. What happens in case evaluation? The parties will summarize their case in a short brief. It's supposed to be short. It gets submitted to a panel of 3 lawyers who hopefully know something about your business. You explain to the panel your dispute, why you think you should prevail. The other side does the same thing. And what the panel does is they don't decide the case, but what they try to do is assign to it what they think is a reasonable settlement value. So if you've been sued for $100,000 for defective goods, but you don't think you've done anything wrong and your goods weren't defective and you've got reasons for that, the panel might say, all right, there's a factual dispute here. This case might go to trial, but we think at this point a reasonable settlement would be for the defendant to pay the plaintiff half, $50,000. And you say, well, that's crazy. Why should I pay anything if I didn't do anything wrong? And that's a good question. And the plaintiff might be saying, and the plaintiff being the word for the party who filed the complaint, and the defendant being the word for the party defending the complaint, the plaintiff would say, well, why should I take less than my $100,000? I'm entitled to all my money. And that's a good question too. And where you usually fall is that recovering that money takes a long time. Lawsuits typically take anywhere from a year to 2 years to resolve at the trial court level. That's going to cost you a lot of money. It's going to interrupt your business. And you may decide that paying something on this claim is worth it because you'd wind up paying the lawyer more. On top of that, you have the risk that you could do everything right and still go to a trial and lose. Now you've paid your lawyer, you've interrupted your business, and you still owe the plaintiff $100,000. So the case evaluation system is intended to try to resolve cases before trial. Does it actually work? Some types of cases it does. Business disputes, in my experience, it isn't really that helpful. Usually because there's often claims flying back and forth between all the parties. We talked about, the plaintiff and the defendant and the co-defendant and the third party defendant and the cross defendant. When you're trying to sort out disputes involving multiple parties, case evaluation, in my experience, doesn't really work very well. Plus, case evaluators don't oftentimes have a real appreciation for the complexity of business disputes. Case evaluation tends to work better in personal injury cases, I believe, or in simple disputes, which is why the next topic becomes more important for the business dispute is facilitation. Facilitation is different from case evaluation because in the state court system, case evaluation is required, whereas facilitation is typically voluntary. What you do is at some point in the process, the parties will simply agree amongst themselves, let's go to this third party and we'll talk with that person, and that person will help facilitate, i.e. push the parties towards a settlement. There are lawyers who specialize in acting as facilitators. And they're trained and they've got experience doing this. And their goal is really to help both sides to see the strengths and weaknesses of their case so that they can develop a willingness to compromise their dispute. In my experience, complex business disputes are much more likely to be resolved in a facilitation than in a case evaluation. Sometimes you'll hear facilitation being referred to as mediation. I don't typically use the word mediation because mediation is actually a term of art in the state court system as well. So I typically use facilitation, but you may hear facilitation and mediation being used interchangeably. You're much more likely to be involved in a facilitation in a complex business dispute, particularly if it's in federal court. The cost of it, and it's typically the cost is your own attorney fees and time. You cover that, and the parties typically split the cost of the facilitator, who tends to charge, just like lawyers do on an hourly basis. It can happen at any time in the case. It can happen at the beginning, in the middle, or at the end. The courts encourage the parties to engage in facilitation, but what they don't like is if you wait until the very end and you're a few weeks before trial and you go to the judge and you say, well, we'd like to stop everything so we can facilitate. The judge isn't going to like that very much, because the judge has to stick to the schedule they have, because they have to answer to people too. So the earlier in the process that you think you might want to try to sit down with the other side to work it out, the better. Facilitation, sometimes they occur even before the lawsuit ever gets filed. Real quick, motion practice. We talked about this a little bit at the beginning, and motion practice is different in state and federal court a little bit. Tends to be a more formal practice. I'll let Eric talk about that a little bit in federal court. But a motion is really just a request to the court to do something. We talked about changing venue. Well, you go to the court and you say, I don't want to fight in Florida. I'd rather fight in Michigan. Please issue an order transferring this case to Michigan from Florida, or transferring the case from Oakland County to Kent County. That's a request is a motion. So if you think of a motion as simply a request for the court to do something, you're fine. Motions can typically be procedural, i.e. things that pertain to where are we going to fight, or how long are things going to take. I asked for documents to be produced and the other side didn't produce all the documents I think I'm entitled to. Order them to produce more records. All of those are things that are accomplished by way of a motion or a request for the court to issue an order. Motions can be filed in state court on 7 days' notice if they're procedural, meaning they don't involve a request to dismiss a case. A procedural motion can be filed on 7 days' notice in state court. A motion that's more substantive, i.e., I want you to dismiss the case because there's no legal basis for it, that typically has to come with 21 days notice. In the federal court system, it's a little different. But state court motions can happen very fast. If I file a motion on a Friday, I can be in Wayne County Circuit Court the following Friday on that motion. And as a responding party, you only have a couple days to get a response together. Eric, do a real thumbnail sketch on the motion practice in federal court, because it's a little different.
It is quite different, because you're going to have your motion filed. If it's procedural and not dispositive, or trying to end the case, you're going to have 14 days to respond, 7 days to file a reply for the person who filed the motion, and then you'll usually get a written opinion from the judge or the court. Although they can make a ruling from the bench after a hearing, quite often you'll get it written, which means it's going to take longer. So it could, even on a simple motion for discovery, it could take 2 months. If you're talking about bigger motions, like motions to dismiss or motions for summary judgment, you can sometimes take 3, 4, 5, sometimes 8 months to get them resolved after they've been fully briefed.
My record is 18 months. 18 months I waited for a federal district court judge to rule on a motion to dismiss a case. So yeah,
Ooh.
Motion practice in federal court is, the bad side is it takes a lot longer. The good side is that the courts tend to look at motions a lot more carefully than they do in state court, simply because the state court judges don't have the staff that the federal judges have, and they don't have as much time.
Or the volume of cases.
Okay. Yeah, or the volume. A state court judge could have hundreds of cases on their docket. A federal judge, maybe half as many, or maybe not even that. I've seen in some busy state courts, they can have thousands of cases on their docket.
Yeah.
So don't be surprised when the judge tells you, the judge didn't remember me, because that happens all the time. All right. We're running out of time fast, so I'm going to jump ahead real fast to settlement conferences. Settlement conferences are precisely what that is. It's a conference with the court where the court takes one last attempt to settle the case before trial. It's like facilitation in some respects, because the judge, him or herself, or if they are actually going to hear the case, they'll refer it to a different judge. They'll actually participate and sometimes get very active with the parties, trying to do what a facilitator would do to try to point out the strengths and weaknesses of a case and help the parties see that they're better off resolving their fight between themselves rather than go to trial and the risks of losing everything. Settlement conferences are going to be set up at the beginning of a case as part of the scheduling order, but they typically happen at the very end of a case before trial. Oftentimes, they can be very close to trial. They can be a few weeks before trial. The bad part with that is, by that time, your lawyer has probably spent all sorts of your money getting ready for a trial, only to be forced to sit down with the other side and try to resolve it. And parties, in my experience, after they've done all the prep work, they don't see the merits in settling the case. If you got a judge who thinks it through, they'll oftentimes try to push the settlement conference out far enough so that the lawyers and the parties aren't having to spend all the money getting ready for trial before they have their settlement conference. Parties are required to attend. So if you're the business owner and you're the decision maker, you're going to have to be there. Your lawyer is going to be there as well. In my experience, settlement conferences are not typically successful, again, mostly because you've already gone through the case evaluation process. You may have gone through a facilitation process. The parties may have had their own discussions. If the case was going to settle, it's typically going to settle before then. But that doesn't mean I haven't had cases that settle at settlement conference. I have. It's just much more rare. Which leads to the crescendo here, trial. We don't have time to go into all the ins and outs of trial, but I can tell you, if you're a key witness, you're going to be there. If you're the business owner, you're the decision maker, you're going to be there. Trial happens when everything else failed. Everything else that's set up in the system to try to resolve the dispute didn't work, and you're going to go to trial. Lots of cases get tried all the time. Criminal cases get tried much more often than civil. Personal injury cases get tried much more often than business disputes. For some reason, business court judges, even the ones set up to do these types of cases, hate trying business court cases. Way too many witnesses, way too many documents. You know, there can be millions of documents involved in a business dispute. And trying to sort through all those in a trial setting is just a very daunting task. Trial court judges just don't like business disputes. I can't tell you how many times I've heard the speech that, look, you guys are sophisticated parties. If you can't settle your case, how in the world am I supposed to decide who's right and who's wrong? And there's some truth to that, but trust me when I say this, some cases simply have to be tried. The parties simply cannot settle it on their own. And you may find yourself involved in a trial, either as a witness, someone who is brought in to authenticate documents that were previously disclosed in discovery. You may be involved, you may not actually be in the courtroom, but you may be in the room when strategy decisions are made or when settlement decisions are considered. There's lots of different ways that people can get involved in a trial but not actually be in the courtroom themselves. It is not like TV. My first trial, I can't tell you how disappointed I was when the trial began and I looked behind me into the gallery and there was nobody there. Not a single person was watching me, you know, in my F. Lee Bailey moment, trying my case. And I thought, where is everybody? Why isn't anyone watching me? And the reason is because trials. Go ahead.
I was saying the citizens aren't showing up on a weekly basis to watch how their courts work.
Nobody does that. Nobody does that. No, my wife keeps saying she's going to do that, but she never does. She watches trials on YouTube. The only people who are going to be in the room are typically the people who have skin in the game. And that isn't to say that you need an audience, but trials are not like on TV. They don't get resolved in an hour. Trials can sometimes take months. Some trials have taken years. Think about O.J. Simpson, how long that trial took. Business disputes, not unusual for business dispute trials to take weeks to resolve. The one war story I want to tell you about TV trials and TV litigation that is going to ruin a lot of TV shows and movies for you. How many times have you been watching a show and I've actually had trials over foreclosure cases, but the property owner is sweating out making the final payment on the mortgage and fear that they're going to lose their property in foreclosure. But just like trials aren't like TV, that's not like TV either. Foreclosure is a very lengthy process that can take years to complete. And simply because a mortgage gets foreclosed doesn't mean the property owner has to move. But that's how it's always portrayed on TV and in movies. Trials on TV and movies are just as false. Trials can be very tedious. They're exhausting. They're time consuming. And above all, they're incredibly expensive. Which is why all of the things we've talked about leading up to this, you people who might be involved in litigation one day need to pay special attention to all of the things we talked about leading up to trial, because 99 times out of 100, your case isn't going to go to trial. It's going to get resolved at some point before trial, which makes all those earlier steps all the more critical. Okay, we are now at noon. So the last thing I was going to talk about, and I can do this in about 30 seconds, are some common litigation mistakes. And the list that we have here should be pretty obvious based on the things that we talked about before, which is ignoring a summons. You only have 21 days to answer. If it sits on your desk because you're afraid to tell anyone that the company got sued and you get defaulted, meaning an order gets entered saying you're liable, that's a bad thing. Failing to follow up on a litigation hold. You get a litigation hold letter from me, but you don't take steps to preserve your evidence. You can get sanctioned, which is a fancy word for saying the court orders you to pay the other side a whole bunch of money because of the documents you allowed to be scrubbed from your system. Assuming the lawyer is going to figure it out. My clients have to be just as involved in my disputes as I am because they lived it, they were there. I can only present the case that they helped me to develop. So you have to be actively involved with your lawyer. And on top of that, using the wrong lawyer. You may have a lawyer that's helping you on your day-to-day business decisions. Sometimes my clients have a lawyer who's also their accountant. They're intimately familiar with the business dealing, but they don't know the first thing about litigation. But the assumption is, well, they're a lawyer, they can do that too. No, they can't. You wouldn't go to a podiatrist because you got a heart murmur. and you wouldn't go to your general practitioner when you need to go to a dentist. You need to find the right lawyer for the right type of dispute. And the good thing about dealing with a place like Plunkett and Cooney is we have a broad range of areas that we can handle. Business disputes, property disputes, corporate disputes, employment disputes, insurance disputes. Last thing I'm going to say, and it's not on the list, but it's something I wanted to touch on, is when you get sued, you can't overlook the fact that you might have insurance to cover the dispute. So if you do nothing else, and hopefully I've taught you today that there's lots of other things you need to do, but you want to make sure that if you get sued and you potentially have coverage for that, you got to put your carrier on notice of the dispute. And the carrier will tell you whether you have insurance coverage to cover either the cost of defense or maybe even the amount of damages that you might ultimately be liable for at the end of a trial. All right, we've gone 3 minutes over our hour. I'm going to blame that on the introduction. It went way too long. I don't know if we have any questions. If we do, we can maybe take a question or two. If not, we can just wrap this up.
Yeah, I'll just remind everyone, this is John again. I'll just remind everybody that if you would like to add a question, just go to the questions window, type that in right now. We do have one that I can ask while we're waiting. Are business disputes typically bench trials or jury trials?
Good question. I almost never ask for a jury in a business dispute. In my experience, jurors don't want to be there. They see it as an intrusion in their life. They were ordered to be there because they got a summons. So a lot of jurors come to jury service hoping that they're going to be excused or trying to come up with some type of an excuse to get them out of it. And you can understand that in many respects. A lot of these people are single earners. If they're not at work, they're not getting paid. And the jury fee for a day might be as trivial as $25. So serving on a jury can be a real problem. So you got that. But on top of that, business disputes tend to be extraordinarily complex, lots of documents involved, lots of witnesses, which isn't to say other areas don't have lots of witnesses as well. But when you're pouring through financial statements, spreadsheets, tax returns, trying to get lay people who may be the most sophisticated transaction they've ever been involved with is their home mortgage. Trying to get them to understand, the issues surrounding antitrust problems with claims on unfair competition. Really difficult. You really have to spend a lot of time trying to educate a jury about the substantive law, which is very problematic. So I prefer business disputes being tried to a judge, particularly if I'm in a business court where presumptively the judge has experience in the type of cases that I'm bringing forward. And that doesn't even get into the issue of arbitration. Maybe we have to do a different webinar on arbitration, but that's another way of having your dispute decided outside of a courtroom, which we just don't have time to get into.
Great, thanks for that, Matt.
It's interesting. I was going to say, just as a practical matter, if you're in a lawsuit and you're a juror, do you want to have your refrigerator instructions read to you while you sit there? It's less interesting versus a car wreck, which people have been in. There's injuries, there's things that people can relate to, which are much harder to do in a business dispute.
Good point.
Definitely, good point. Last question I see, is there any such thing as a point of no return in litigation, like a default on a matter?
Okay. So a lot of the things we've talked about, particularly case schedules, you have to do by court order. We have to complete certain things by certain times. We have to file a witness list. We have to complete our discovery. We have to file motions, for going to by a certain date. most of litigation matters are handled by a schedule. On top of that, just to file certain claims, you have to bring them within a certain amount of time, which is called the statute of limitations. So, for example, if you have a contract dispute outside of the Uniform Commercial Code, you have 6 years to bring that dispute. So if someone breaches my contract today, I have 6 years to file a claim. Believe it or not, people will sometimes wait 6 years to bring the claim. Something like that is a point of no return. There's no redemption after you've blown your statute of limitations. Just about everything else, when problems, deadlines are missed, are often fixable, but you got to act promptly. So the worst thing you can do when something gets overlooked or mistakes were made or deadlines were missed is to sit on it and hope it goes away or it won't turn out to be very important. Your lawyer can usually at least try to undo the problem, but they've got to know about it as soon as it happens. Because waiting, the longer you wait, the more likely it is the judge will decide there's nothing that can be done, because they're not going to rewrite the whole schedule simply to accommodate your mistake.
Great. Thanks for that, Matt. At this point, I don't see any other questions, so I'm going to go ahead and wrap things up and just remind everybody that at the end of the program here, when you sign off, you should receive a survey. We'd love for you to fill that out. Helps us plan our future events, and we always like to know how we did, so please do that. The other thing I wanted to remind everybody of is this program is being recorded, and the recording will be available on our website probably later today, possibly tomorrow. So if you missed something, want to review it again, or refer somebody to this recording, please check it out on plunkettcooney.com and just look for our events page. And we also want to give a quick plug to our group's Don't Bet the Business blog. If you like to follow risk management topics and other issues related to commercial and business litigations, this is the place to be. Our attorneys write on a number of different topics, including Matt doing a lot of the heavy lifting. So check it out. A lot of good information there for you as well. So on behalf of Matt Betcher and Eric Johnson.
John?
Yep.
John?
Yes.
Real quick.
Yes, go ahead.
We had to go pretty fast. So if there are questions about any of the topics we covered today that are still confusing or you're not sure how they interplay, feel free to shoot me or Eric an email and just ask us a question. And if it's something we can answer through an email, we'll certainly do that.
Great. That's awesome. Thank you very much for that. All right. So that concludes today's program. We want to wish everybody a great rest of the day, and hopefully we'll see you down the road at another one of our events. Take care, everyone.